Usually, when we think of a constitutional crisis, we picture something straight out of a political thriller. High-stakes meetings in Washington, Supreme Court gavels coming down, maybe like a massive protest on the steps of the Capitol. It feels distant. It feels grand. But what if I told you that one of the most persistent, slow-burning constitutional crises in American history didn't start in a marble building? It started over dirt and cows.
And more specifically, the cost of grazing those cows on that dirt. And who actually has the authority to set those rules?
Right.
Because that is where the real friction begins.
Exactly. Today, we are looking at a stack of historical, legal, and policy sources to explore the mechanics of the constitutional roots of the Sagebrush Rebellion. And just to be completely clear with you from the start, this isn't a story about modern political personality.
No, not at all.
We aren't taking sides here, and we aren't endorsing anyone's viewpoints. Our mission is to look strictly at the legal architecture of a proxy battle over federal sovereignty and land use conflicts in the American West.
But sticking to the legal mechanics.
Right. The guiding question we want you to keep in mind today during this deep dive is this: how did a mundane local dispute over grazing fees evolve into a full-blown constitutional theory that challenges the fundamental basis of federal authority?
To really understand how we get to that point, we have to rewind and look at the historical context of Western expansion, because the stakes we are dealing with are incredibly real.
Yeah.
They're real for the ranchers whose livelihoods and family histories are tied to this dirt, and they are real for the federal officials who are legally mandated to manage it.
Yeah.
If you look back over a century, the federal government's entire posture toward the American West was, well, essentially to give it away.
Like a massive liquidation sale.
Precisely. I mean, you had the Homestead Acts, the mining laws. The explicit goal of the United States government was to encourage citizens to move west, settle the land, improve it, and eventually own it. Yeah, the federal government was operating essentially as a real estate broker, liquidating its inventory to build a nation. You go out there, you survive the elements, you build a ranch, you run your cattle, and the promise was that your sweat equity would eventually translate into a deed.
Okay, let's unpack this. Because reading through the sources, understanding that expectation seems crucial to understanding the anger that follows.
It's the whole foundation of it.
Right, because if you are a ranching family, you aren't just camping on public land. You are investing massive amounts of capital. You are building irrigation systems, putting up miles of fencing, managing herds over decades.
Exactly.
You are doing all of this under an implicit and often explicit social contract with the government that you are on the path to ownership.
That is the exact psychological and economic reality. Generations of families built their entire existence around this specific cultural expectation. They saw themselves as prospective owners, actively participating in the long tradition of settling the West.
Right.
But then the real estate broker decided the inventory was no longer for sale.
And this brings us to the exact moment the rules of Western expansion changed overnight. The year is 1976.
Yeah, 1976 is the pivot. Congress passes a piece of legislation called the Federal Land Policy and Management Act. We'll just refer to it as FLPMA.
Okay, FLPMA.
And FLPMA did something monumental in the history of American land law. It officially ended the era of homesteading. It declared, in no uncertain terms, that the millions of acres of remaining Western lands would remain permanent federal property.
Wait, permanently?
Permanently. They were not going to be handed over to private citizens. They were not going to be handed over to the states. They belonged to the federal government forever.
Imagine being on a rent-to-own lease.
Yeah.
Your parents were on this rent-to-own lease. Your grandparents were on it. You've poured your blood, sweat, and money into improving the property, operating under the assumption that eventually, you get the title. And then one morning, the landlord knocks on the door and announces, hey, great news, this is now a rent-only agreement forever. I'm keeping the house, but you can stay as long as you follow my new rules and pay my new fees.
It completely fractured the relationship between local landowners and the government. Overnight, ranchers were transformed from prospective owners into permanent tenants of the federal government.
That's wild.
It was a stroke of a pen in Washington that severed a century-old social contract. And because these ranchers were now permanent tenants on federal land, a massive structural problem emerged. You now had overlapping legal jurisdictions that were fundamentally incompatible.
Because the state laws and the federal laws suddenly applied to the exact same physical space but said completely different things.
Yes. Our sources point out two irresolvable legal conflicts born directly out of FLPMA. Let's start with the first one, the sovereignty crisis. This is the clash between federal land authority and state water law. To understand this, you have to understand how water works in the American West, which operates under something called the Prior Appropriation doctrine.
I was actually looking at the sources on this water rights issue, and it seems completely counterintuitive to how the rest of the country handles property.
It really is.
Like if I buy a piece of land in Ohio, I generally have the right to the water on that land, but out west, the dirt and the water are completely separate legal entities.
That's a great way to look at it. In the East, you have what are called riparian rights. The water rights are tied to the land adjacent to the river, but the West is incredibly arid.
Right.
If water was only available to people who owned the riverbanks, you could never build a town or a ranch miles away. So Western states developed the Prior Appropriation doctrine. It essentially means first in time, first in right.
First in time, first in right.
Exactly. You can own the legal right to divert and use water without owning the land beneath it, as long as you are the first person historically to put that water to beneficial use, like agriculture or mining.
Let me stop you there to make sure I'm getting the physical reality of this.
Yeah.
If I'm a rancher, my great-grandfather might have secured the state water rights to a natural spring back in, say, 1890.
Okay, yeah.
Under state law, that water is my constitutionally protected private property. But under FLPMA, the federal government now permanently owns the millions of acres of dirt surrounding my water.
That is exactly the situation. Legal scholars call this a split estate sovereignty crisis.
Oh, yeah.
It's like owning the engine of a car, but someone else legally owns the chassis and the keys to the garage.
Oh, wow, that's a great analogy.
You have a rancher who holds a state-recognized property right to a water source, but that water source is located miles deep inside newly declared permanent federal land. Now imagine the federal agency, let's say the Bureau of Land Management, steps in and says, we manage this land now to protect an endangered sage grouse, so we are closing the access road.
So my property right to the water is legally intact, but physically useless because I'm legally barred from crossing federal dirt to get to it.
You are literally trapped between two competing masters.
You are. The state says the water is yours, the federal government says the land is theirs, and that leads directly into the second major conflict, which is the livelihood crisis.
Okay, what's that one?
This is where federal environmental regulations clash with the rancher's livelihood claims, and it manifests in the real world as bitter disputes over grazing fees and land use.
Because the federal government is no longer just holding the land to eventually sell it. Under FLPMA, they have a legal mandate to manage it for multiple use.
Correct. The federal government has to balance ranching with recreation, mining, logging, and environmental conservation. So they start implementing regulations to protect endangered species and prevent overgrazing.
Makes sense on paper. Right. From the perspective of a federal land manager, they are simply executing the laws passed by Congress to protect a national resource for all Americans. But from the rancher's perspective, well, these new regulations often mean arbitrarily reducing the number of cattle they can graze.
Which hurts their income.
Exactly. Or exponentially increasing the fees they have to pay just to keep their business afloat on land they've been operating on for generations.
When your family's economic survival depends on water you legally own but can't access without federal permission, and grazing lands you need but can't afford or are barred from using, the friction isn't just a hypothetical legal puzzle.
No, it's not.
It's an existential threat to your way of life. But here is the critical pivot in our story. When legal codes contradict each other this profoundly, the conflict doesn't just stay neatly inside a federal courtroom. It spills over into the physical world.
It spills over specifically because of the physical reality of the American West. There is a massive enforcement gap.
The enforcement gap.
Yeah. We have these complex overlapping laws on paper, but the federal agencies tasked with enforcing them, like the Bureau of Land Management or the Forest Service, face a logistical nightmare. They have jurisdiction over hundreds of millions of acres.
Sources outline the sheer scale of this, and it's staggering. You might have one or two federal law enforcement officers responsible for an area the size of Connecticut.
It's a profound lack of on-the-ground capacity. They lacked the personnel, the resources, and frequently the political will to enforce federal law consistently across these vast, isolated stretches of land.
Right.
And when the designated referee fails to show up, the players on the field start making their own rules. This lack of presence is exactly what created the physical space for armed resistance.
Here's where it gets really interesting. Because we move from abstract constitutional theory into physical standoffs, The sources provide two specific case studies that perfectly illustrate this enforcement gap boiling over the 2014 Bundy standoff in Nevada and the 2016 Malheur occupation in Oregon.
Yes, those are the major flashpoints.
Let's look at the mechanics of those impartially, just to see how this structural failure manifests.
If we look at the 2014 standoff in Nevada, you have a rancher who had actively refused to pay federal grazing fees for over 20 years.
20 years?
Yeah. His justification was based entirely on the sovereignty arguments we just discussed. He argued his family's historical use of the land and state water rights superseded federal jurisdiction, and that the federal government legally could not own the land.
Because of the enforcement gap, he was able to just keep grazing his cattle for 2 decades without paying.
Exactly. But eventually, the federal agencies secured court orders and moved in to confiscate his cattle to pay the accumulated debt.
And that's when things escalated.
Extremely fast. When they did, hundreds of armed supporters arrived from all over the country to physically block the federal agents. It resulted in a tense standoff that ended with the federal government actively backing down and releasing the cattle to avoid a bloody shootout.
And then just 2 years later, we see this escalate even further in Oregon.
Yes, the 2016 Malheur occupation. A similar ideological group, including some of the same individuals from Nevada, physically took over the headquarters of the Malheur National Wildlife Refuge.
So they took over a building this time.
Yes, this was an armed occupation of a federal facility that lasted for over a month. Their explicit demand was that the federal government relinquish control of public lands and turn them over to local county control.
I have to pause here because reading about these events, they don't look like spontaneous protests.
It's not at all.
If we connect this back to our legal analysis, these standoffs look like a direct structural result of the enforcement gap itself. Does a long-term lack of enforcement essentially create a void that invites armed resistance?
The sources strongly suggest that it does. The enforcement gap turned an abstract legal argument into a physical reality. If a federal regulation says you cannot graze your cattle in a certain valley, but you do it anyway for 20 years and no one stops you because there is no ranger for 100 miles, well, you begin to establish a de facto reality on the ground that completely supersedes the de jure, or paper, reality in Washington.
You prove that the law only exists if someone forces you to obey it.
Exactly.
But to sustain that kind of armed resistance, especially drawing people from across the country, you need more than just a logistical advantage. You need a narrative. You need a justification to explain why you are pointing a weapon at a federal agent.
You definitely do.
Out of the chaos of this enforcement gap, the resistance developed a legal framework to legitimize their actions.
And that framework is a radical theory known as county supremacy. It emerged directly from these local conflicts in the West over land and water.
Break the mechanics of this theory down for us, because reading it on paper is quite the experience.
It really is. The theory of county supremacy makes a very specific claim that the county sheriff is the highest, most supreme law enforcement authority in the country.
Wait, over the federal government?
According to them, yes. The logic they use is that the sheriff is the highest elected law enforcement official at the local level, making them directly accountable to the people in a way that an appointed federal bureaucrat is not.
And they take that idea to an extreme conclusion.
Very extreme. Proponents of county supremacy argue that the sheriff possesses the legal power to veto federal law within their county borders.
Wow.
They claim the sheriff can dictate how federal lands are managed, ignore federal environmental regulations, and crucially, they argue the sheriff has the authority to arrest federal agents if the sheriff subjectively believes those agents are acting unconstitutionally.
Okay, we need a massive reality check here. This has absolutely no basis in constitutional law.
None whatsoever.
The Supremacy Clause of the U.S. Constitution is unambiguous federal law trumps state and local law, period. If a county sheriff tried to arrest an FBI agent for enforcing federal law, that sheriff is going to federal prison. So if this theory is legally hollow, if it gets laughed out of any federal appellate court, why does anyone pay attention to it? Why are we dedicating time to it in a legal deep dive?
Because if we connect this to the bigger picture, the brilliance and the extreme danger of county supremacy isn't about winning a formal legal case, The proponents of this theory don't care what an appellate judge in Washington says.
Right, they care about what happens on the ground.
Exactly. It functions as a highly effective, practical deterrent on the dirt roads of the county.
It weaponizes the enforcement gap.
Precisely. Imagine you are a local federal land manager. You are a regular person doing your job, making $40,000 a year. You need to issue a citation to a rancher for illegally diverting water.
Okay.
But you know that if you drive out there, hundreds of armed individuals might show up to block your truck. And on top of that, the local county sheriff might publicly side with the ranchers, go on local television, and threaten to arrest you for trespassing.
You are going to second guess going out there.
You are going to stand down. And that is the point. County supremacy is a mechanism of deterrence. It makes the physical cost of enforcing federal law so high that the agencies simply choose not to do it.
So the theory is legally bankrupt, but practically it is a resounding success.
Yes.
This brings us to an incredible structural irony that the sources point out, because this reliance on local deterrence over federal authority actually mirrors a massive, entirely legitimate Supreme Court ruling. We just have to look at it with a physical armed twist.
Yes, to really understand how wild this legal landscape is, we have to look at the landmark 1997 Supreme Court case, Printz v. United States.
I remember reading about this in the sources. It had absolutely nothing to do with land or cows. It was a gun control case.
Exactly. Printz was a case involving the Brady Handgun Violence Prevention Act, a federal law passed in the 1990s. The Brady Act temporarily required local chief law enforcement officers, mostly county sheriffs, to perform background checks on people trying to purchase handguns.
So the federal government essentially said, hey, we don't have the local infrastructure to run all these checks, so we are mandating that local sheriffs do the paperwork for us.
Right. But a couple of county sheriffs, and it's no coincidence that they were from Montana and Arizona, out west sued the federal government.
Oh, interesting.
Yeah, they argued that the federal government could not force state or local officials to execute federal law, and the Supreme Court agreed with the sheriffs.
This established the anti-commandeering doctrine.
Yes. The Supreme Court ruled that the federal government cannot commandeer state or local officials to enforce federal mandates. It is a massive legal shield that allows for passive state non-cooperation.
Passive non-cooperation.
Right. The court essentially said if the federal government wants a federal law enforced, they have to send their own federal agents to do it. They cannot force the local sheriff to do their work.
So, synthesizing this, we have the Printz decision, which legitimately says local authorities can passively refuse to help the federal government. If the feds want to check a background or stop a cow from grazing, the sheriff can legally say, "Not my problem, do it yourself."
Exactly.
But the grand irony of the Sagebrush Rebellion is that these groups took that passive legal shield, added the legally bogus theory of county supremacy, and escalated it into active armed deterrence.
That is the ultimate takeaway here. Printz says you don't have to help the federal government. County supremacy says you can actively point a gun at the federal government to stop them from doing it themselves.
That incredible.
And because of the vastness of the West and the enforcement gap, it actually works. What we are seeing is a reality where federal supremacy exists firmly on paper, but remains entirely optional in practice in certain areas.
So what does this all mean for the future? We started our journey in 1976 with FLPMA, a sudden policy shift that turned hopeful Western settlers into permanent federal tenants.
A huge shock to the system.
Right. That legislative earthquake created a split-estate sovereignty crisis, where ranchers legally owned the water, but the government physically controlled the land, leading to existential conflicts over grazing fees and livelihoods.
Exactly.
And because the federal government severely lacked the resources to enforce its own rules across millions of acres, an enforcement gap opened up. Into that physical void stepped armed standoffs, justified by the radical but practically effective theory of county supremacy.
And the policy implications of this moving forward are staggering. How can the government manage public lands? How do they protect vulnerable habitats, issue mining permits, or manage scarce water resources if their constitutional authority is practically voided by local deterrents?
It seems almost impossible.
It is. When a federal agency drafts a new environmental regulation today, they don't just have to ask if it's scientifically sound or legally defensible in court. They have to ask if trying to enforce it on the ground will start a local armed conflict.
It really forces you to view a mundane argument over grazing fees in a completely different light. It's not a story about a parking ticket. It is a stress test of the United States Constitution itself. And before we go, there is a fascinating thought experiment hidden in the sources that we want to leave you with.
Yes. If county supremacy and armed deterrence can successfully create a de facto reality where federal law is optional on public lands in the West, what happens if other groups study this history and adopt this exact same blueprint of homemade sovereignty?
That is a wild thought.
Right. What if radical environmentalists occupy a logging site in a remote forest and use local armed deterrence to prevent federal agents from removing them? What if autonomous urban zones in major cities use the exact same logic to declare federal law null and void within a few city blocks?
Wow.
If the lesson of the Sagebrush Rebellion is that paper laws only matter when they are enforced, is sovereignty ultimately just a matter of who holds the ground?
If you can hold the dirt, you make the rules. It's an incredible look at how law actually functions in the real world. Thank you for joining us on this deep dive into the legal mechanics of the American West. Keep questioning the ground you walk on, and we will catch you next time.